Justice Ketanji Brown Jackson issued a pointed dissent from the Supreme Court's decision, permitting the federal administration to advance certain aspects of its mail voting executive order. She cautioned that the court's ruling could precipitate electoral disorder and place states in an untenable position regarding the timing of legal action, risking dismissals for being either premature or belated. In her 23-page dissent, Justice Jackson argued that the decision contravenes long-standing judicial principles that guide equitable discretion and unnecessarily introduces instability into the forthcoming midterm elections. Justice Jackson articulated concerns that the court's approach has led to a Kafkaesque nightmare for plaintiffs seeking redress in election-related disputes, placing them at risk of losing the opportunity for timely judicial intervention. The majority granted the federal administration's request to lift a lower court's injunction, which had previously halted the enforcement of parts of the executive order in 23 states and the District of Columbia. The unsigned opinion stopped short of addressing the order's overall legality, focusing instead on the procedural argument that the state's challenge lacked the requisite concrete injury at this stage. The majority opinion emphasized that any future government action under the executive order might still be subject to legal scrutiny, suggesting that the lawfulness of specific measures would have to be evaluated as events unfold. In response, Justice Jackson underscored that the states were already facing tangible impacts, including increased election planning costs, threats of prosecution, and uncertainty regarding potential alterations to mail ballot protocols. Jackson criticized the court's rationale, describing it as a catch-me-if-you-can approach that complicates the determination of when election-related issues are sufficiently developed for judicial review. Historically, the court has cautioned against modifying election procedures in close proximity to Election Day. Jackson argued that the present decision introduces the opposite risk, effectively discouraging timely challenges by suggesting they might be dismissed as premature. She contended that the majority's opinion distorts established doctrines of standing and ripeness, resulting in a ruling that could exacerbate pre-election confusion rather than resolve it. Additionally, Justice Jackson highlighted what she characterized as a lack of situational awareness on the part of the majority, noting the administration's pursuit of emergency relief while simultaneously asserting uncertainty about the executive order's implications. The executive order in question directs federal agencies to develop state-specific citizenship lists and instructs the Attorney General to prioritize investigations and prosecutions involving allegedly ineligible voters. It further mandates the U.S. Postal Service to implement regulations concerning mail-in and absentee ballots, including requirements for ballot envelopes, introduction of tracking barcodes, and state-specific voter lists. Implementation efforts were reportedly underway, though the election timeline may constrain the extent of changes before November. Justice Sonia Sotomayor, joined by Justice Elena Kagan, issued a separate dissent, maintaining that the plaintiff states already experienced direct and imminent injuries sufficient to justify their legal challenge. The matter will continue to be litigated in the lower courts, with the Supreme Court's order temporarily staying the lower court's injunction as the case proceeds through the appellate process. Justice Jackson concluded by asserting that the issues presented were clear, and that permitting the administration to proceed risked significant confusion and potential disruption ahead of the midterm elections. She argued that when executive actions threaten state prerogatives in ways not sanctioned by the